My mother-in-law stood up in the middle of that meeting room and told everyone I had stolen from her son. I sat perfectly still. I did not cry. I did not defend myself. I just waited. Let me tell you how I ended up in a boardroom in downtown Toronto with my husband's entire family staring at me like I was something they had stepped in. My name is Heather Malone. I am 31 years old and I work as a licensed insolvency trustee in Ontario. What that means, practically speaking, is that I spend my days inside other people's financial disasters. I review bank records, trace hidden assets, identify fraudulent transfers. I have sat across the table from business owners who embezzled from their own companies, from spouses who tried to hide assets during divorce proceedings, from adult children who quietly drained their parents' accounts, while those parents were too proud or too confused to say anything. I have seen every version of financial betrayal that exists between people who are supposed to love each other. I have filed the paperwork on all of it. My mother-in-law did not know any of this when she decided to come after me. Her name is Beverley. She is 63 years old and she has lived in Oakville, Ontario her entire life in the same house she and her late husband bought in 1989. She volunteers at her church. She bakes shortbread at Christmas. She has a photo of the Queen on her wall, the old one, which tells you something about her. She is the kind of woman who can make you feel like a guest in your own home without ever raising her voice or saying anything you could specifically object to. She has never liked me. I figured that out within about 45 minutes of our first meeting. My husband is her youngest son. His name is Owen Malone, and he is a structural engineer who takes his coffee black and leaves his socks on the bathroom floor and once drove 4 hours in a snowstorm to bring me soup when I had the flu. He is a good man. He's also the kind of person who genuinely believes that people are mostly trying their best, which is a quality I find both deeply lovable and occasionally exhausting. We met at a mutual friend's cottage on Georgian Bay 6 years ago. We got married 3 years later in a small ceremony in Collingwood with 30 people and a playlist Owen spent 2 months curating. His mother wore gray to our wedding. Not silver, not champagne. Gray. Like she was attending something she had been obligated to show up for. I have never said that out loud to Owen. Some things you just file away. Owen's father passed away 18 months before all of this started. His name was Douglas, and he was a quiet, methodical man who had worked for the same insurance company in Burlington for 31 years. He died of a sudden cardiac event in his sleep, which is the kind of death that leaves everyone stunned because there was no time to prepare and no chance to say the things you meant to say. He was 66 years old. He had been planning to retire the following spring. Douglas left behind a will that he had updated 14 months before his death. He left the family home to Beverley. He left his registered retirement savings, which had grown to a little over $300,000 over 3 decades of careful contributions, split equally between his 2 sons. Owen and his older brother, whose name is Scott. That was it. That was the whole estate, more or less. Modest by some standards, but Douglas had earned every cent of it working 45 years of 9-to-5 days and packing his own lunch. Beverley contested the will 6 weeks after the funeral. She did not contest it because she had been left with nothing. She had been left with the house and her own pension and survivor benefits from Douglas's work plan, which together gave her a reasonable and stable income. She contested it because she believed that Owen had influenced his father in his final years, that he had manipulated a grieving and emotionally vulnerable man into changing the will in Owen's favor. The original will, the one from 12 years earlier, had left everything to Beverley outright. According to her filing, Owen had spent too much time alone with his father. He had driven Douglas to too many appointments, helped him with too many tasks, been too present during a period when his father was, as her lawyer put it, emotionally susceptible to influence from a devoted child. She was accusing my husband of undue influence. She was accusing him of taking advantage of his own father's grief to redirect an inheritance. And then, almost as an aside, she mentioned me. Her supporting statement included a claim that I had advised Owen on the legal mechanics of will modification, that my professional background had been used to guide a scheme to divert assets, that I was the architect of it. I read that paragraph 3 times. Then I set the document down on our kitchen table, and I made myself a cup of tea and I sat by the window for a long time looking at the snow in the backyard. Owen wanted to call her immediately. He wanted to drive to Oakville and sit down and explain everything and clear this up face to face, because that is what Owen does. He solves things by talking them through. It is one of his best qualities and, in this particular situation, exactly the wrong approach. I told him to wait. He asked me what I meant. I told him I needed a few days. I told him not to contact her, not to contact Scott, not to say anything to anyone until I had a clearer picture of what we were actually dealing with. He looked at me the way he sometimes does when I shift into work mode, like he is not entirely sure which version of me he is talking to. He said, okay. He trusted me. That mattered more than I could tell him in that moment. I called my own lawyer the next morning. Her name is Constance, and she practices estate litigation out of a small firm on King Street West. She is 60 years old, and she does not waste words or time. She read the filing and told me it was aggressive, but not without some legal grounding. Undue influence claims in Ontario are notoriously hard to prove, she said, but they are also hard to fully dismiss. The process would be slow and expensive and genuinely unpleasant. She asked me what I wanted to do. I told her I wanted to understand the full picture before we decided anything. That night, I sat at my desk and I started doing what I do. I was not just Owen's wife in this situation. I was a licensed insolvency trustee with 15 years of experience following paper trails through complicated family finances. I knew exactly what questions to ask and exactly where to look for the answers. I started with what I knew. Douglas had updated his will 14 months before his death. That meant there had been a lawyer involved, a proper process, a signed document with witnesses. That did not happen because Owen drove his father to a few medical appointments. That happened because Douglas had made a decision. I requested a copy of the updated will through Constance. I reviewed the name of the estate lawyer who had drafted it. I called that lawyer's office, introduced myself, explained the situation, and asked whether they could confirm the circumstances of the will revision without breaching solicitor-client privilege. The assistant I spoke to was careful but informative. She confirmed that the appointment had been requested by Douglas directly. She confirmed that Owen had not been present for any of the meetings. She confirmed that the file noted Douglas had explicitly declined to have family members accompany him. That was the first thing. The second thing came from Owen himself, though he did not realize it at the time. I asked him to walk me through the last 2 years of his father's life. Not the emotional parts, not the grief. The logistics. Where did they go? What did they do? Who else was involved? Owen talked for almost 2 hours. He told me about driving his father to cardiac monitoring appointments at Hamilton Health Sciences. He told me about the Tuesday lunches they started having at a Tim Hortons on Plains Road. He told me about the afternoon Douglas had asked Owen to help him sort through boxes in the basement, old files from his insurance work, and how they had spent 4 hours going through paper records Douglas had kept since the 1980s. That last detail caught my attention. I asked Owen what kind of files. He said he was not really sure. Policy documents, claims records, some personal finance folders. He said his father had been meticulous, everything labeled, everything dated. He said they had moved most of it to a storage unit in Burlington because his mother had wanted the basement cleared and Douglas had not wanted to throw anything away. I asked if we still had access to that storage unit. Owen looked at me for a moment. Then he said yes. We drove to Burlington on a Saturday morning in January, which is exactly as cheerful as it sounds. The storage unit was a 10 by 10 space filled with banker's boxes and a set of golf clubs Douglas had apparently not used since 2008. Owen had the access code. We let ourselves in. I spent 3 hours in that storage unit with my laptop and a portable document scanner I used for work. What I found was not a smoking gun in the dramatic sense. It was something quieter than that and, in some ways, more devastating. Douglas had kept detailed personal financial records going back to 1991. He tracked every significant transaction in a set of spiral-bound notebooks, one per year, each one labeled in his careful handwriting. Income, expenses, transfers, gifts. The notebooks were cross-referenced with manila folders of supporting documents. Bank statements, receipts, correspondence. I get to the last 4 years of notebooks first. In the final 2 years of his life, Douglas had made a series of transfers that were not reflected anywhere in the estate documentation Beverley's lawyer had provided. 11 transfers over 22 months, amounts ranging from $4,000 to $18,000 each. Total value just over $112,000. Every single one of those transfers had gone to the same account. The account belonged to Scott, Owen's brother, the one Beverley had been living with for the past 8 months, the one who had, according to Beverley's own filing, supported her fully during this difficult period. I sat on a folding chair in that storage unit for a long time without moving. Douglas had not been manipulated into updating his will. He had updated it because he had been quietly supporting one son financially for years, and he wanted the estate distribution to reflect what he had actually intended for the other. He had not told anyone because he was a private man who handled his own affairs and did not believe in airing family finances. He had, however, written it all down, because that is what careful people do. I scanned every notebook. I scanned every supporting document. I photographed the folder labels in sequence. I sent copies to Constance that evening with a summary memo that took me 4 hours to write. She called me the next morning at 7:45. She said she had not slept much. I told her I had not either. She said, "This changed the picture considerably. The transfers to Scott were not illegal on their own. Parents give money to their children, but the pattern, combined with the timing of the will revision, suggested a very specific explanation for why Douglas had made the choices he made. It also suggested that Beverley, if she had been aware of these transfers, had filed her challenge with incomplete information, or worse. I thought about that for a long time. There was something else in those notebooks, a single entry near the back of the second-to-last spiral, written in Douglas's handwriting, dated about 8 months before he died. He had written, spoke to B about the Scott situation. She knows. Said, to keep it between us. Not sure that's right. B was Beverley. She had known about the transfers. She had known why Douglas had revised his will. She had filed a legal challenge anyway, naming her other son's wife as a co-conspirator in a scheme that had never existed. I thought about Owen driving 4 hours in a snowstorm to bring me soup. I thought about the gray dress at our wedding. I thought about 31 years of Douglas packing his own lunch and setting money aside for his retirement, and the quiet, careful way he had tried to be fair to both his sons, even when it cost him something, and how Beverley had turned that into a legal attack on the people he had trusted most. I did not feel angry in the dramatic, explosive way. I felt something colder than that. Owen read the notebook entries late that night. He sat at our kitchen table with the scanned images on his laptop, and he did not say anything for a very long time. When he finally looked up, he had an expression I had not seen on him before. Not rage, not grief, though there was some of both. It was something more like the look you get when a picture you have been looking at your whole life suddenly resolves into a completely different image. He asked me what happened now. I told him I thought we should let them walk into that room, still believing they had won. There was a mediation session scheduled for the following month. Beverley's lawyer had requested it as a preliminary step before formal litigation. Constance had agreed strategically because at that stage we had not yet shown our hand. This session was held at a neutral office on Bay Street. A mediator, a retired judge named Patricia, whom I recognized from professional circles, presided. Beverley sat across the table with Scott beside her and her lawyer on her other side. Owen sat next to me. Constance sat at the end. Beverley looked composed. She was wearing a navy cardigan I had seen before, one she wore to church events. She had a folder of documents in front of her that her lawyer had organized into a neat stack. Her lawyer opened by summarizing the claim. Undue influence. Owen's excessive involvement in his father's final years. My professional knowledge deployed in service of redirecting an estate. He was polished and measured and completely confident. Then he invited Beverley to make a personal statement. She spoke calmly at first about her grief, her loss, her sense that Douglas's final wishes had not been properly respected. Then her voice shifted. She pointed at Owen and said that she knew what he had done. that he had always been the one Douglas favored, that he had used that position to take advantage of a man who was not thinking clearly. She said I had coached him. She said I had used my professional expertise to exploit a grieving elderly man. Owen's hand went still on the table. I kept mine folded in my lap. Patricia, the mediator, watched Beverley's statement without any change in expression. Then she turned to our side of the table. Constance did not give a speech. She set a single document in front of the mediator and said that we had materials we believed would reframe the discussion. She started with the estate lawyer's notes confirming that Douglas had initiated the will revision independently without Owen present and had explicitly declined to have family members involved in the meetings. Beverley's lawyer made a note on his pad. Constance then presented the transfer records from Douglas's notebooks. 11 transfers over 22 months, totaling $112,000, all directed to Scott's account. She laid out the timeline on a single clear page. Douglas had been quietly supplementing Scott's income for nearly 2 years before his death. The revised will, which split the RRSP equally between both sons, had been Douglas's way of restoring a balance he had already disrupted in Scott's favor. Scott looked at the table. Beverley looked at Constance. Constance read the notebook entry aloud, quietly, without emphasis. Just the words Douglas had written in his own handwriting. Spoke to B about the Scott situation. She knows. Said to keep it between us. Not sure that's right. The room was very quiet for a moment. Patricia looked at Beverley's lawyer. She asked if he had anything to add in response. He asked for a brief recess. I watched him lean over to Beverley during the break and speak quietly into her ear. I watched Scott's jaw tighten. I watched Beverley's expression move through a sequence I recognized, confusion first, then something calculating, then this specific kind of pale that comes when a person realizes the version of events they committed to no longer holds up. She looked at me then, really looked at me, maybe for the first time since Owen had brought me home to meet her 6 years ago. I did not look away. When the session resumed, Beverley's lawyer announced that his client wished to withdraw the challenge. Patricia noted the withdrawal for the record. She also noted that the materials presented raised questions beyond the scope of mediation, and that she was recommending both parties seek independent legal counsel before concluding the matter. She did not say anything else. She did not have to. I want to tell you what happened after that room, because the room itself was not the end. Constance filed a formal response to the estate records with the court, attaching the full documentation from Douglas's notebooks. The transfers to Scott became part of the official record. This mattered because it meant that when the estate was finally settled, the documented financial history was part of the picture. The estate lawyer confirmed the validity of the updated will. Owen and Scott each received their share of the RRSP. Scott's share, as it turned out, was somewhat smaller than what he had already received from his father over the preceding 2 years, though no one made a legal issue of that. It was simply the truth, sitting there in Douglas's handwriting. Beverley and I have not spoken since that mediation session. I do not expect we will, not in any meaningful way. Owen called her a few weeks later. She answered, but the conversation was short and did not go anywhere useful. He came home quiet and made dinner and did not say much about it. I did not push him. Some things have to settle at their own pace. Owen's colleague, a woman who had met Beverley once at a firm event, asked him at some point how things were going with the family. He said it was complicated. She nodded and did not ask anything else, which was the right response. We had brunch with my own parents on a Sunday in March, the kind of ordinary meal where my mother worries about whether I am eating enough, and my father talks too long about a home renovation he is planning. I sat at their table and drank bad coffee and felt something I had not felt in months. Normal. Just ordinary and normal. Owen proposed in April. He did it at the little French bistro on Roncesvalles, where we had eaten on our first real date years ago, the one where I talked for 45 minutes about forensic accounting. And he listened like it was the most interesting thing he had ever heard, which I later found out it actually was. Because Owen is genuinely strange in the best possible way. I said yes before he finished the sentence. My professional standing had never actually been in jeopardy, but the challenge had landed in my firm's awareness, and my managing partner had called me in for a quiet conversation 2 weeks after the filing. He believed me. He said so directly, but he wanted me to know that the file existed and that I should keep him informed. I told him the situation would resolve cleanly. He nodded and said he trusted my judgment. When Constance sent him a copy of the final documentation, he called me and said simply that it had resolved exactly as I had said it would. He did not apologize for the conversation we had had before, which I respected more than an apology would have earned him. He just moved forward. That is the right way to handle things. I went back to work. I took on a new file the following week. A 67-year-old woman in Kitchener whose son had been making unauthorized withdrawals from her account for 8 months. Small amounts. The kind designed to stay just below the threshold that triggers automatic review. I recognized the pattern immediately. I knew exactly what to look for and exactly where to find it. We recovered the full amount. Her son was charged under the Criminal Code of Canada. She cried when Constance called her with the news. Not because she got the money back, she told us, but because someone had believed her when she said something was wrong. I thought about Douglas in his storage unit in Burlington, writing everything down in his careful spiral notebooks, because he knew the numbers told the truth, even when the people involved could not. I thought about the Sunday mornings my own father spent going through his budget spreadsheets at the kitchen table, a habit he had kept for as long as I could remember, which had seemed tedious to me as a child, and now struck me as one of the most quietly courageous things a person could do. I kept Douglas's notebooks. Not the originals, those went to the estate file, but I kept my scanned copies, not as evidence. That chapter was closed. I kept them because they were the record of a man who had tried, imperfectly and quietly, to take care of the people he loved, who had not been able to say out loud the things he felt, but had written them down in careful columns because that was the language he knew. Some people think the point of all this is the moment in the room when the other side goes pale and the papers land on the table and everything shifts. And I understand why. That moment is real and it matters, but that is not actually what stays with you. What stays with you is the drive to Burlington in January with the snow coming down on the highway and Owen in the passenger seat, not asking questions, just being there. What stays with you is 4 hours on a folding chair in a storage unit, cold enough to see your breath, going through someone's whole financial life, one notebook at a time, and finding the truth folded inside it, quiet and patient and waiting. What stays with you is that careful people leave traces. And if you know how to follow them, the truth will hold. I keep thinking about Douglas in that storage unit. Not the legal version of him, not the name on the estate file. The actual man, sitting at a kitchen table somewhere in Burlington on a Sunday evening, opening a new spiral notebook, writing the date at the top in careful block letters, and beginning again. Another year of numbers, another year of telling the truth, the only way he knew how. He did not get to defend himself. He was not in that mediation room, but he had done the work long before any of this started, and that work held. There is something I have come to believe through this, not as a professional conclusion, but as something more personal. The people who cause the most damage in situations like this are rarely the ones who act out of pure malice. Beverley is not a villain in the way that word usually gets used. She is a woman who was grieving, who was afraid, and who made a choice to protect what she felt she was owed rather than to look honestly at what had actually happened. That gap between what we feel we deserve and what is actually true is where most harm gets done, not through cruelty, but through the decision to stop looking clearly. What saved us was not luck. It was 3 things that I think about now when I take on a new file at work, when I sit across from someone who has been wronged and needs someone in their corner. The first is integrity. Douglas had it. He wrote down transfers he was not required to document. He recorded a conversation with his wife that made him uncomfortable. He noted his own uncertainty. He did not make himself look better in those notebooks than he actually was. That kind of honesty, the kind that persists even when no one is watching, is the foundation of everything that came after. Without it, There was no record. Without the record, there was no truth to find. The second is the willingness to think clearly under pressure. Owen wanted to drive to Oakville and talk it out the night we got that letter. I understand that impulse. It comes from a good place. But there are moments when the most important thing you can do is slow down and actually look at what is in front of you before you decide how to respond. I have seen people lose everything because they reacted before they understood. Sitting with the discomfort of not knowing long enough to actually find out what is true is harder than it sounds. It requires a kind of mental discipline that does not come naturally to most of us, including me. I had to practice it that January. The third is the persistence to keep going when the process is slow and unglamorous and cold. Nobody tells you about the folding chair. Nobody tells you about 4 hours in a storage unit that smells like old paper and rubber, scanning documents page by page in a space just warm enough to keep your hands functional. There was no dramatic moment in that room in Burlington. There was just work. Careful, repetitive, necessary work. The kind that does not make for a good story until later. I think about Heather Malone, the 31-year-old woman who sat in that mediation room with her hands folded in her lap, and I think about Douglas, who never got to see any of it, but who had, in his quiet way, made sure she could win. He kept receipts, so do I, and it turns out that is enough.